Well, hello and welcome to this webinar on intercompany agreements. My name is Paul Sutton and I'm one of the partners at LCN Legal. And the focus of this workshop today is the legal implementation of financial transactions from a transfer pricing perspective. So what we're going to cover is some, first of all, by way of introduction, we'll look at some areas where financial transactions from a legal perspective have a different nature compared to others. We'll just reconfirm what are we trying to do here when we are legally implementing transfer pricing policies. We'll go through the basics of loan agreements and loan notes. We'll talk about cash pooling, both notional cash pooling and physical cash pooling. We'll talk about guarantees, implicit guarantees and parent company support. And we'll do a recap on the 10 commandments or the basics that ICA's intercompany agreements for all transaction types need to comply with. So just a couple of housekeeping things before we start. First of all, if you have any questions, any comments as we go along, please do use the chat function. And I'll do my best to address them as we go, but if not, I will pick them up at the end. The second thing is we are recording this webinar, so please don't share any confidential information in your questions or comments. So just a little bit of background in case you haven't come across us, LCN Legal, before. We are a law firm. We are corporate lawyers by background. We're not tax advisors or transfer pricing advisors. Our specialism is the legal design of intercompany agreements and the legal implementation of group reorganizations. We work alongside tax and transfer pricing professionals across the world, and that includes both TP advisors in advisory firms, but also in-house TP professionals. So in the context of this webinar, I'm not going to talk about the TP methods as such in relation to financial transactions. I'm looking at the legal perspective on how TP policies are or may be implemented. So just by way of background, in terms of intercompany financial transactions, at LCN Legal, we read a lot of TP policies. And I would say that 9 times out of 10, when we're asked to review transfer pricing policies for a group, actually they don't deal with financial transactions. So I'm always quite curious as to why loans and guarantees from a TP perspective seem to be rather unloved. Is it the case that they are the Ringo Starr of intercompany transaction types? I would love to hear from you maybe later as to why you think that may be the case. But from a legal perspective, I just want to talk about how loans and financial transactions may be different from a risk profile perspective compared to other transaction types. So the first point is that liquidity risks for the legal entities involved may be more obvious, maybe more transparent than for other transaction types, because if a legal entity is making a loan or is receiving a loan, there's clearly a liquidity risk, a credit risk involved for the legal entities, and therefore the question as to whether this is a transaction that the directors of each respective legal entity can properly approve. So I would say that it's probably true to say there's an enhanced personal liability risk for directors, and we'll come on to this in particular when we talk about cash pooling arrangements. So that's points 1 and 2. Point 3 is that legal entities may be subject to legal restrictions on their ability to lend. So this is something that is mentioned in the OECD's TP guidelines, the 2022 version, as we all know, the legal environment is part of the environment that needs to be taken into account in setting TP policies. So to give a COVID-related example, groups which may have gone through financial distress in COVID may have received government support in the form of grants for employees or workers, or also government-backed loans. And that financial support is likely to come with very specific legal restrictions as to how the recipient of that aid can actually use the cash that it has received. And generally speaking, those legal terms would prohibit the relevant legal entity for then contributing that cash to maybe a cash pool or to lend it to an associated entity in a different country. So those legal restrictions certainly need to be considered and taken into account when designing the transactions to start with. Point number 4 is that loans and similar arrangements can have a very direct impact on the reserves position of individual legal entities, and may also have a knock-on effect in terms of the accounting treatment and whether those entities can continue to file accounts on a going concern basis. So just to give one recent example that we came across, so if you imagine a subsidiary company which granted a loan to a sister entity, so not to the parent, but to another subsidiary of the same parent. Originally, when that loan was put in place, it was repayable on demand. However, the borrowing company was in financial distress, and in order for the borrower's accounts to be signed off on a going concern basis, the decision was made to extend the term of that loan, so convert it from an on-demand debt to a 12-month term, which all sounded very sensible. The problem was, from a reserves position for the lender did not have sufficient distributable reserves to cover the amount of that debt that was converted into a longer term debt. And therefore, from a company law perspective, that variation in the loan terms actually constituted an unlawful reduction of capital, and it needed to be unwound and redocumented in order for both companies to be able to file their accounts. So that's just one very direct example of the interrelationship between the legal terms of debt, intercompany debt, and some very basic company law issues. So relating to that is point number 5. So the position or the relative position in the group structure chart of the lender and the borrower may be a key factor in the legal analysis of it, and therefore whether that lending or that debt relationship can go ahead in the form proposed. So clearly, from a TP perspective, you may be disregarding that associated or the common control, but from a legal perspective, that will almost always be a key factor that needs to be looked at. And finally, well, there's the transfer pricing perspective, which is that arguably loans and financial transactions are more likely potentially to be recharacterized as a different transaction altogether for TP purposes. So, for example, debt being recharacterized as equity, particularly if the original terms of the transaction as documented lack commercial substance or economic substance. So those are some of the headline reasons why financial transactions perhaps should be treated different and should be given more consideration, not just from a TP perspective, but also from a legal perspective. So I'd just like to recap in terms of what are we trying to achieve here. And if you attended our workshop last month, then you'll be familiar with this diagram, which is just one way to look at the world. So from our perspective, our joint task as lawyers working alongside TP professionals is really just to help the corporates survive TP audits with the minimum of pain. In other words, it's to give them robust TP positions that they can then successfully defend as and when the TP audit, the tax audit comes. And in order for those TP positions to be robust, the positions need to be based on firm foundations, and that's symbolized by the 4 legs of the table here. So one leg is the legal entities involved, including, as mentioned, the relationship between those legal entities and their individual interests. Another leg is the functional analysis from a TP perspective. So clearly that needs to be carried out in a robust manner. The agreements, the legal agreements clearly need to be aligned both with the legal entities and with the functional analysis. Otherwise, when it comes to that TP audit, we've got the legal documents and the TP filings telling a different story. And then finally, the comparables and price setting, obviously that needs to be in line with the other 3 legs. And the basic and obvious point is that you can't even start to look at comparable transactions until you have delineated the controlled transaction. And for financial transactions, conduct will only get you so far, probably not very far at all in terms of understanding the commercial substance of the arrangement. So really, that there's no clear way of delineating a financial transaction without a legal agreement and the terms of those legal agreements. So let's look at the basic legal terms for intercompany loans. And I'm sure that when you look at this list, you'll say, well, this is really quite obvious. You might be surprised at the number of agreements that we are asked to review where there is a complete mismatch between the legal terms and the intended transfer pricing analysis, and also where there's a mismatch between the legal terms and arrangements which the directors of the individual entities could properly approve. And we've got a prime example of that in the Singapore Telecom case, which we'll come on to. So looking down that list, number one, obviously the principal amount of the advance or the amount of the facility needs to be clearly specified. Number two, a key distinction from a legal perspective is whether the loan facility is a committed facility. In other words, is the lender legally obliged to lend or to make additional advances if conditions precedent are satisfied, or is it an uncommitted facility? So just a framework agreement within which the lender and the borrower may or may not agree to make and receive certain advances. So a basic understanding of what is actually the level of commitment, the level of obligation reflected by the agreement, that's absolutely critical. Point number three is the term or repayment date. So it may be a simple term loan with a defined repayment date, but you also need to look at what are the early repayment options. In other words, does the borrower have the option to repay or prepay the loan early at its option? Does the lender have the option to demand repayment of the loan early as well on certain notice being given? So you clearly need to understand that. Point number four, clearly specifying interest rates, whether they're fixed or floating. Also the interest payment dates, the compounding of interest. These are all fundamental terms. Point number five, security and ranking. So for obvious reasons, it's less common within intercompany loan agreements for there to be security in the sense of collateral, so charges over underlying assets, simply because of the administration involved and because of the possible knock-on effect on flexibility. And usually the only security that is given is some form of cross guarantee or parent company guarantee. However, when we're looking at ranking, as I'm sure you know, it's really quite common for intercompany loans to be expressed to be subordinated. In other words, that usually means that the lender can only demand repayment and can only accept repayment if all other creditors of the borrower have been satisfied or provided for. So clearly that's a key term in terms of pricing the transaction. Warranties, covenants, and undertakings is a really interesting idea. For those of you who've been involved in negotiating or reviewing third-party debts, you'll know that loan facility agreements are often 150 pages, 200 pages, even longer, and that's let alone the security package and the ancillary documents. And very often in third-party lending arrangements, you'll have very detailed covenants and undertakings. The TP guidelines talk about incurrence covenants and maintenance covenants. So incurrence covenants are promises by the borrower to do something or not to do something. For example, a covenant not to dispose of the assets or not to grant other security. Maintenance covenants relates to things like financial ratios, which the borrower is required to maintain and would amount to an event of default if they were not to be maintained. So in theory, all those types of provisions could be reflected in intercompany loan agreements. The proviso, just like any procedural provisions in intercompany agreements is that there's no point in having those detailed covenants and undertakings unless they are being actively monitored on an intergroup basis and they're being complied with on an intergroup basis. Because clearly, if you have prescriptive terms requiring submission of reports, provision of information, or compliance with financial ratios, for example, but those covenants are not being actively monitored and appropriate actions are not being taken, then that's just going to undermine the integrity of the whole documentation. So generally speaking, we would advise against including those kind of detailed covenants and undertakings unless there was an extremely good reason for doing so. Point number 7, events of default. So this tends to be a relatively boilerplate clause in short form. So this is setting out the circumstances in which the lender may demand repayment of the loan early, for example, insolvency events or material breach on the part of the borrower. So those we would certainly recommend are included in short form. Point number 8, specifics regarding payment provisions. So obviously the currency of the loan is a key term for pricing purposes. You often also see gross up clauses. So this is a clause which relates to withholding tax, which may apply to payments of interest, and in effect says that if a withholding tax applies, then the borrower needs to pay an additional amount on top of the contracted rate of interest, such that the net amount received by the lender is equal to the specified amount. So again, in theory, it's completely proper to have a gross up clause in an intercompany agreement. I would, however, say that you should think carefully whether or not it is appropriate, because by and large, it's the borrower, so often subsidiary entities, which are least able to manage and monitor that risk. And obviously, a gross up clause has the effect of placing that risk onto the borrower as opposed to the lender. And then finally, fees. And again, whilst in third-party agreements, it is completely common to have arrangement fees, transaction fees, and so on. It's recognized in the TP guidelines that often those fees in a third-party context relate to costs which actually don't apply in an intra-group context. So it's relatively unusual to provide for the payment of additional fees in intercompany loans. So those are, I would say, are the key or the basic terms that you need to make sure are included and clearly specified in your intercompany loan agreements. Overarching that is the requirements that the whole arrangements need to be appropriate within the context of the business and the legal entities involved. So some key points here. Firstly, as is specified in the TP guidelines, the purpose of the loan needs to be clearly understood. In some cases, that may be actually documented within the loan agreements itself. In other cases, it may be documented in the TP policies or in the corporate approvals or briefing notes. Either way, it needs to be clearly specified. Second point, as mentioned before, is that you do need to dig behind the group structure and make sure that you're identifying any key restrictions from a legal perspective or a liquidity perspective, director's duties perspective, which may influence the form or content of the loans. And then finally, as for any other intercompany agreements, you need to have an appropriate governance procedure whereby the loan is actually signed up, so it's not just seen as a rubber stamping procedure, and that the process of putting the loan in place actually respects the role and the duties of the boards of directors of the individual participating entities. So that's I would say that's becoming more and more important. And again, we'll talk about the Singapore Telecom example here. So I'd just like to talk about loan notes. And by the way, just to remind everyone, if you do have questions or comments, please do use the chat function. And I'll do my best to address them as we go along. So as many of you will well know, it's very common for intercompany debt to be in the form of a security, so a loan note or a bond, and in many contexts, from a legal perspective, those terms of bond and loan notes are interchangeable. In terms of how the structure works from a legal perspective, the way that they are documented is that there is an overarching document called the loan note instrument, which is only signed by the borrower, and that sets out the terms of the debt, so including all the commercial terms that we've just been talking about, such as the currency, repayment dates, interest rates, interest payments, and so on. And then within the context of that loan note instruments, the borrower then issues individual certificates known as loan notes, which incorporate by reference the terms of the loan note instrument. So it's a bit like the way that a company issues shares and share certificates, with the rights attaching to those shares being set out in the constitution of the company. Loan notes on a loan note instrument is just a contractual way of achieving the same thing. And as I indicated before, there's no difference in terms of commercial and legal functionality between those two ways of documenting loans, so a conventional loan agreement or a loan note instrument. In other words, whatever you might want to do in terms of the commercial terms, you can reflect in either of those two forms. However, there are differences in terminology and administration, as indicated on the table on this slide, that you really do need to be aware of, and I would say think twice before you use a security form, a loan note, unless there's very good reason for it. So in terms of terminology, the borrower under a conventional loan becomes the issuer of the loan notes, the issuer of the promises to pay that is reflected by those loan note certificates. The lender then becomes the subscriber for the loan notes or the note holder. A repayment of the loan, that becomes the redemption of the loan notes. So in other words, when a loan note is satisfied in full, then the loan note holder actually needs to submit that loan note certificate to the issuer for cancellation, a bit like a cancelled share. A further advance or additional advance under the arrangements would be reflected by the issue of additional loan notes under the loan note instrument. If interest is rolled up under the terms of the debt, then in the loan note scenario, that may be reflected by the issue of a payment in kind note, also known as a PIK note or a funding bond. So that's one way of adding or rather capitalizing interest and adding it to the principal. An assignment of a loan by a lender becomes a transfer of a loan note, similar to a transfer of a share certificate or other form of stock. Whereas assignment by the borrower is actually not at all straightforward to document from a legal perspective when you're talking about loan notes, and it generally speaking means tearing up the original loan notes and redocumenting it altogether. And some of the situations that we've come across have involved corporates who have previously put in place loan notes, maybe as part of a transaction, but have then not continued to administer that structure in line with its legal nature. For example, they haven't properly documented redemptions or advances or whatever, and therefore they've ended up with a legal paper trail, a legal set of documents which doesn't match the accounting and the financial and the tax understanding, and that's caused problems later which needed to be rectified. So I'd like to move on and talk about cash pooling arrangements, and this is probably one of the highest risk transaction types from a legal perspective, perhaps not so much from a transfer pricing perspective, but I'd just like to go through some of the issues from a legal point of view. So as you probably know, there are two main types of cash pooling. One is notional cash pooling, and the other one is physical pooling. So notional cash pooling is effectively an arrangement or a facility which is made available by the bank. It doesn't involve a physical transfer of cash between the participating group members, but what it involves is the bank notionally netting off the different balances, whether they're credit balances or debit balances, across the different bank accounts, so as to reduce or maybe even eliminate the interest which is payable by the group, and also to maximize the interest which is received by the group if it's a net credit balance. So that's the general nature of the arrangement. In terms of the legal documentation, so this is primarily documented as between the bank and the cash pool members. So because it's a service in effect which the bank provides, it's primarily the bank's own documentation which governs the functionality of that arrangement. Generally speaking, a notional pooling arrangement like this will involve cross guarantees. So like any cross guarantees or intercompany facilities, these may have a very significant liquidity impact for the individual participating entities involved. So they need to go through an appropriate governance process in firstly deciding whether or not that from a legal entity perspective, it is proper to participate in that notional cash pooling arrangement, and also they need to review that on an ongoing basis. And then finally, in terms of notional cash pooling, it may be that the cash pool leader is actually carrying out minimal functions from a TP perspective, basically because all of the functions or all of the significant functions are being carried out instead by the bank. So that's notional cash pooling. Physical cash pooling, by contrast, involves regular cash sweeps. So it's in effect the cash pool participants giving ongoing authority to the cash pool leader to instruct automated, regular, probably daily cash sweeps from their bank accounts to the accounts of the cash pool leader. This means that the participants are directly giving up control over their individual bank accounts. They are exposing themselves to the credit risk of the cash pool leader. So in order for a legal entity which is contributing cash and participating in the cash pool, they are relying on the credit rating, the credit worthiness of the cash pool leader to meet any demands for cash that legal entity may have in the future in order to pay its own creditors. So that credit risk, liquidity risk, can give rise to very serious concerns depending on the cash position of the group as a whole and the financial strength of the group as a whole. So over the last 12 months, 18 months, and especially during the COVID period, in many cases where we've been asked to advise on physical cash pooling arrangements, it's actually been primarily due to concerns from the participating entities as opposed to transfer pricing being the primary concern. In terms of legal documentation, so the primary documentation is actually an internal agreement between the cash pool leader and the individual members, to which the bank is usually not a party. And that's in that agreement, the range of the functions carried out by the cash pool leader are specified, obviously in a manner consistent with the intended TP analysis. And in addition, the agreement would specify the interest rates that apply for cash pool participants, both on credit balances and debit balances. And it may well be that it's the spread between those two interest rates that constitutes the primary remuneration or compensation for the cash pool leader. Physical cash pooling arrangements may or may not involve cross guarantees, but like any financial arrangement, you need to dig behind the specific transactions that you may be looking at here, and you need to understand the broader financial structure of the group, and whether, for example, third-party facilities granted to the group actually already involve cross guarantees given by the participating entities. And as mentioned before, the cash pool leader in a physical cash pooling arrangement may well be carrying out significant functions, and as mentioned, those would need to be documented both in the TP policies, but also in the legal agreements, the cash pooling agreements. the key takeaway here is that because there are significant liquidity risks on an ongoing basis for participants, and because under many, if not most, jurisdictions across the world, directors can be subject to personal liability if they approve transactions without proper regard to the interests of third-party creditors. That means that cash pool arrangements are never a set and forget type of arrangement. It's an intrinsic part of the structure that the legal entities need to build in regular review and reconsideration as to whether they should continue to participate in the cash pooling. And depending on the circumstances involved and the financial strength of the group, that may involve monthly reviews, even weekly reviews, quarterly reviews. It's certainly not going to be as infrequently as annually. So all those things really flag up the fact that cash pooling arrangements should not be entered into lightly, and they probably highest amongst all intercompany transaction types, they will require the most local law review and consideration before they can be implemented. So let me go on and talk about guarantees and parent company support. And I'm using the Singtel case as a mini case study, although, of course, in that particular case, it didn't involve guarantee fees at all. It was a straight transfer pricing challenge to the interest rate. As you'll remember, the case concerns loan notes put in place between two entities. So the issuer or the borrower under the loan notes was STAI, which is an Australian company, and had just acquired a third-party group, so a group acquired from Cable and Wireless, represented by the abbreviation SOPL. The lender was a Singapore tax resident BVI company, and it was a 5.2 billion Australian dollar loan notes as first set out. So I don't want to go into the transfer pricing treatment or the pricing methods or the different pricing methods for parent company guarantees. I'd just like to reiterate the legal perspective of guarantees and what they actually mean for the legal entities involved, and more to the point, what they don't mean. So let's imagine in that case that Singtel, the parent company, had actually granted a legally binding guarantee in favor of the lender to support or secure the obligations of the borrower. So one key thing to understand there is that even if such a guarantee had been granted, that would not change the financial position of the borrower. Because if you imagine that the guarantee had been granted in legally binding form, let's say the borrower had defaulted and the lender had called on that guarantee such that Singtel, the parent, had paid out, STAI, the borrower, would still remain liable for the whole amount. So a guarantee is not the same as a legally binding obligation to provide financial assistance or financial support. So all that would have happened in that case is that the borrower's creditor would have changed from the original lender to the guarantor, and that's simply because the guarantor in effect steps into the shoes of the original creditor. So that means that when you're looking at guarantees, excuse me, whether they are implicit or explicit, it's usually only part of the story in order to make the transaction make sense from a legal entity perspective. Second point to make from a borrower's perspective is actually the first bullet point on this slide, and relates to implicit parent support. So as you'll know from the Singtel case, when the court was assessing the interest rate and applying the arm's length principle, it was looking at two key factors. One is the impact of implicit parent company support on the credit rating of the borrower, and the second was the legal terms of the debt. So it was those two planks, if you like, that formed the starting point for the court's analysis. However, aside from the transfer pricing view of the world, even if from a TP perspective, an implicit or implicit guarantee should be taken into account, it's a completely separate matter for the borrower as to whether actually that makes sense, and as to whether the directors can rely on that implicit support in the absence of a legally binding guarantee. So from the lender's perspective, it's a similar set of considerations. So even where from a TP perspective, the view may be taken that the credit rating of the borrower should be enhanced, those factors may or may not constitute sufficient grounds for the lender to bear that risk, and it may be that the lender needs to insist on a legally binding guarantee in order to be able to go ahead with that. The overarching point to make here is really the key lesson from the Singtel case, which is documentation of the commercial rationale for the arrangements is absolutely essential. So it's no longer sufficient to have a robust TP analysis. It's no longer sufficient on top of that to have clear legally binding implementation of that. But in addition, there needs to be that documentation of why it made sense from the individual perspectives of all of the legal entities involved for them to go ahead with the transaction in that form. So that's a key part of the defense files. And as you'll remember, a key area where Singtel fell down in that case, because clearly they'd failed to document the commercial rationale. And that meant that the court was having to resort to reconstruct the reasons for it by looking at emails between the client Singtel and its advisors, which were EY at the time. And even that attempted reconstruction was insufficient from the court's perspective. So finally, before we wrap up, I'd just like to reiterate the point that the 10 commandments, or the basics of intercompany agreements, still apply for financial transactions as for every other transaction type. So number one, agreements need to be clear and unambiguous. They need to be as short as possible. 3, they need to be aligned with the contracting model, the financing model, and the legal environment. So the legal environment is part of the reality, is part of the functional analysis here. Number 4, they need to be aligned with transfer pricing policies, because that's one of the key aims of the exercise here. We're looking for transfer pricing, tax audit ready arrangements, and with that consistent picture being shown. Number 5, the legal agreements need to be aligned with the other needs of the group, and that includes treatment of withholding tax, asset protection considerations, and so on. Number 6, they need to be aligned with directors' duties. In other words, the golden rule is, if you put yourself in the situation of being a director of each of the respective legal entities, would you sign, or would you need to ask for additional clarification or additional legally binding assurances? Number 7, the agreements need to be concluded in advance. This is not a post-year end matter. Number 8, as we mentioned, the commercial rationale needs to be documented as part of the defense files. Number 9, the agreements need to be stored in a comprehensive central archive such that they can be easily and quickly accessed as and when needed. And number 10, just like everything, they need ongoing review and maintenance in order to make sure that they continue to reflect the needs of the group and the external reality. So hopefully that's been helpful in meaning that financial transactions are no longer the Ringo Starr of the TP world, or at least they're getting more love than they got before. Any questions? Any comments before we wrap up? In case you'd like to join next time, so next month's webinar will be focusing on limited risk transactions and how to document them from a legal perspective so as to support the TP policies. And all that remains is to say thank you very much for joining, and I look forward to seeing you next time. Thank you.